Whenever we have a session with Mr. Shangar Murali, an advocate from High Court of Madras, we definitely get a different flip to the legal mind and otherwise also, because he takes the intricacies of any topic to such a deeper dive that you always have few points which enrich your knowledge. And today's session is intricacies of Benami Transaction Prohibitions Amendment Act 2016. This session is divided into two parts, so it is approximately 1 hour each. And as usual, Legal Elites is a necessary partner whenever Mr. Shangar Murali is here, because the connecting bridge was Adi Lakshmi ma'am, who had helped us to connect with Mr. Shangar Murali. We are thankful to both of them. Over to you, Adi Lakshmi ma'am, and then to Mr. Shangar Murali.
Good afternoon, everyone. Mr. Shangar Murali sir is a very known person here down south. But today, after joining Beyond Law CLC, Shangar Murali sir's legal acumen is known to far and wide, length and breadth of our country. And the credit goes only to our most respected and beloved Shangar Murali sir. And he is a guru's guru, and he trains the trainers also. Many of the lawyers who take sessions get ideas from his sessions. So he's not only training the students of law, he's training the trainers of the law as well. And today he's going to take a very important topic. And to get an appointment today with Shangar Murali sir is so very difficult, because he's been doing sessions after sessions, doing very many cases, length and breadth of a country. Not only the high courts, even Supreme Court sir is doing lots and lots of matters. He's a encyclopedia on the civil law, and he's a person who's ready to learn the nuances of the law. And thank you once again, Vikas, for inviting Shangar Murali sir on this platform and inviting Legal Eagles Allied to do the honors. And welcome, sir, on behalf of Beyond Law CLC and Legal Eagles Allied and all the participants who have joined in. Welcome, sir. Welcome so much.
Over to you, Shankar.
Yes. Thank you. It is my pleasure to give lecture. I thank Mr. Vikas ji and Adi Lakshmi for giving this opportunity to give my lecture on the nuances of Benami laws. I tell you one thing, the Benami, Prohibition of Benami Property Transaction Act 1988 and the recent 2016 Amendment Act, both are unfathomable statutes. It cannot be understood easily. There are a lot of nuances and intricacies. Even the judges very often are unable to give the proper perspective regarding these Benami laws. Who is a Benamidar? And who is the real owner? That's a point. Before the advent of the 1988 Act, property can be purchased by any person in the name of another person from and out of his own funds. That is not prohibited, because Section 82 of the Trust Act authorizes such a transfer. It has occupied the field for the past more than 100 years. So many cases have been filed by the real owner. Real owner is the person who has purchased the property in the name of another by providing his own funds as sale consideration. He is the real owner. In whose favor the property was purchased, he is the Benamidar, otherwise known as ostensible owner. So before the advent of the 1988 Act, if any dispute arose between the Benamidar and the real owner straight away can file a suit for declaration to declare his title to the property on the ground he has purchased the property in the name of the defendant Benamidar, and the Benamidar has no wherewithal to purchase any property. The entire sale consideration was paid by him, and he is the custodian of the original documents and the prior title deeds, and he is paying the revenues, kist, and he is in possession, or he is not in possession, he can ask for recovery of possession. So the real owner can very well file a suit for declaration of his title against a Benamidar before the advent of the 1988 Act. That has been recognized because of the Section 82 of the Trust Act. Now, why the property was purchased Benami? The reason is very obvious. To avoid tax, to defraud the creditors, and to avoid other statutory dues, and defeat the sealing law. In Tamil Nadu, we are having Tamil Nadu Agriculture Land Sealing Act, whereby and whereunder one person is entitled to hold only 9 standard acres. If any properties are purchased by him, the excess land will be declared as excess land, and it will be taken away by the government, and in turn it will be distributed to the other landless people. The very object of the Sealing Act to prohibit accumulation of wealth in one hand and for the ratable distribution of the land to the landless. That is the very object. So in order to avoid the land sealing laws, Income Tax Act, government dues, and to cheat and defraud the creditors, the Benami transaction took place. In order to cut this menace, the Law Commission, in its 57th Law Commission report, submitted its report in the year 1973. But this act came in the year 1988 after the expiry of nearly about 15 years by the Law Commission, 138th of the Law Commission report. In the Prohibition of Benami Property Transaction Act 1988, purchasing property Benami is prohibited, but it was not criminalized then. What was prohibited? It's a point to be considered. Under Section 3 of the 1988 Act, no person shall enter into any Benami transaction, provided husband can purchase property in the name of his wife or in the name of his unmarried daughter for their welfare. The presumption is, if any property is purchased by a husband in the name of his wife or unmarried daughter, it is for their welfare. That is for the maintenance of the wife and the marriage expenses of the unmarried daughter. If it is proved that it was not intended for the benefit of the wife or daughter, then the husband can very well file a suit for declaration to declare his title to the property purchased by him in the name of his wife or unmarried daughter, as the case may be, by rebutting the legal presumption enshrined under Section 3 of the Old Act. I was also under a impression that once the husband is able to rebut the presumption under Section 3, that the properties was not purchased not for the benefit of the wife or unmarried daughter, he can very well file a suit for declaration of his title. But recently, our Madras High Court, by the Honorable Justice N. SSSI, said, no doubt the husband can be able to rebut the presumption. When he is able to rebut the presumption that the property purchased by him in the name of his wife, not intended for the benefit of wife. So the presumption can be rebutted. If he pleads further that the property was for his benefit, then Section 4(1) will come into picture and he cannot make any claim that the property is a Benami property. I will tell you one reason. Section 4(1) and 4(2) of the 1988 Act contains two limbs, 4(1) and 4(2). Under Section 4(1), if any property is purchased, Benami, the real owner cannot file a suit for declaration of his title to declare his title on the ground entire purchase money was paid by him and the dependent Benamidar has no wherewithal to purchase property in his name. So that suit is prohibited under Section 4(1) of the 1988 Act. Section 4(2) contemplates if the suit is filed by the Benamidar against the real owner after the advent of the 1988 Act, no defense can be taken by the original owner that the plaintiff Benamidar is not the real owner, he is the real owner, he has paid the entire sale consideration. So, the conjoined reading of Section 4(1) and 4(2) points out the insurmountable fact no suit will lie to declare the title of the real owner, and no defense will be allowed to be taken by the real owner as against the Benamidar after the advent of the Act. The Honorable Supreme Court in Mithilesh Kumari versus Prem Bahari Kare, reported in AR 1989 Supreme Court, page 1247, held that the Benami Transaction Act, particularly Section 4(1) and 4(2), are retrospective in nature. But it raised several questions regarding the applicability of the retrospective nature of the Benami 1988 Act. Then finally, the matter was referred to larger bench. In the larger bench, that is in the case of R. Rajagopal Reddy versus Badmini Chandrasekharan, reported in AR 1996 Supreme Court, page 238, gave a landmark verdict that the Benami Transaction Act 1988 is not retrospective in nature, it is prohibitory in nature. The 1988 Benami Transaction Act does not affect the sale deed or transaction that took place prior to the advent of the 1988 Act. Suppose any property is purchased in the 1960, 70 or 80, that sale is valid. This Benami Transaction Act has no retrospective effect. Provided, after the advent of the 1988 Act, if any suit is filed by the real owner in respect of the property purchased by him in the name of the Benamidar prior to the advent of the Act, his suit is barred under Section 4(1). To that effect, the Benami Transaction Act is retrospective in nature. Similarly, if any suit is filed by the Benamidar against the real owner prior to the advent of the Act, but on the commencement of the Act, if any suit is pending, the defendant real owner ought to have filed his written statement taking the plea of Benami prior to the commencement of the Act. If no written statement is filed, no defense is taken on the commencement of the Benami Transaction Act 1988, and the defense of the real owner is prohibited under Section 4(2) of the 1988 Act. This is the major verdict, important verdict given by the Supreme Court. And by this judgment, the judgment in Mithilesh Kumari versus Prem Bahari Kare was overruled. Now, the present Act, 2016 Act, it is named as Benami Transactions Prohibition Amendment Act 2016. It made some sweeping changes in the Benami Transaction Act. Earlier 1988 Act, it has not criminalized the Benami transfer, but under this new Act, it is criminalized. Not only that, if it is proved that any property is purchased, transferred, if any Benami transaction is made, the property involved under the transfer can be confiscated by the central government. and criminal prosecution can also be launched. It is non-cognizable. The plea bargaining is also not applicable. Once property was purchased by the real owner in the name of the Benamidar, Benamidar has no right to retransfer the said property in favor of the real owner. That retransfer is also prohibited under the Act. But property was purchased by X in the name of Y. Y is the Benamidar. X is the real owner. Real owner. This is a Benami transaction because entire sale consideration was paid by X to purchase the property in the name of Y. If it is brought to the knowledge of the authorities, namely Assistant Commissioner or Deputy Commissioner of Income Tax Act, who are the initiating officer under the new Act, once it is brought to the knowledge of the authorities, they will issue show cause notice under section 24 subclass 1 of the new Act 2016. Once the show cause notice is issued, no further transfer will be allowed. Now one may raise a question. Sir, before the issuance of the show cause notice, the Benamidar sold the property. Whether the sale is valid or not, the sale is valid. So what is prohibited? Once the show cause notice is issued to the Benamidar under section 24(1) of the Amended Act 2016, the Benamidar has no right to encumber or alienate the property held by him Benami. Before the issuance of show cause notice, any transfer is made that is valid because the transferee will be considered as a bona fide purchase of a value, purchasing property without knowing the transaction, whether it is a Benami or not. Benami or not. This new Act 2016 repealed section 81, 82 and 94 of the Trust Act, section 66 of the CPC, and section 281A of the Income Tax Act 1961. Under the earlier Act, suppose if any property is purchased by the real owner in the name of Benamidar, that is prohibited. Suppose the Benamidar sold the property before the issuance of the show cause notice, retained the sale consideration with him, then by way of cash, then that cash is considered as a Benami property. It can also be attached by the initiating officer. So it does not confine to the immutable property. It may be a share or cash. Suppose real owner may deposit, may give cash to the tune of 1 crore or more, and he may deposit in the safe locker of the Benamidar, then such amount will be considered as a Benami property that can also be confiscated. Then this new Act made some sweeping changes and defined who is a Benamidar and who is the beneficial owner. Earlier Act, real owner. Now the term is used as a beneficial owner. Now under this new Act, it exempts certain transactions from the operation of the Benami laws. They are under section 2 subclass 9. They are under section 9. It carved out certain exceptions. The karta of a joint family or co-partnership property may purchase property in the name of any one of the members of the joint family or in the name of the one of the co-partner, provided the purchase money must be from the known source of income. The word is very much has to be taken note of, from the known source of income. Then persons in fiduciary relationship, namely partners trustees, father and son, executor, trustees, they are also entitled to purchase property in the name of trustee or partner or persons in fiduciary relationship. That is also exempted. And one of the spouse may purchase property in the name of spouse or in the name of any child, provided the purchase money must be from his known source of income. This property purchased by husband in the name of wife and unmarried daughter, not for her welfare, that has been omitted. Now, the brother or sister are also entitled to purchase property in the name of their brother or sister, as the case may be, provided there must be some document to show that they have been arrayed as joint owners in respect of any property. If such a document is in existence, then the sister or brother, as the case may be, they may purchase property Benami in the name of brother or sister. So these are all certain exceptions carved out under the new 2016 Amended Act. Then this Amended Act 2016 defines who is a Benamidar. Who is a Benamidar? Section 10 means a person or a fictitious person need not show his identity, as the case may be, in whose name the Benami property is transferred or held, and includes a person who lends his name. So, in whose favor the property was purchased, transferred, he may be a known person, identifiable person, or fictitious person, and who lends his name to purchase the property in his name. They are all Benamidar. Then who is the beneficial owner? In other ways known as real owner. Beneficial owner means a person, whether his identity is known or not, for whose benefit the Benami property is held by a Benamidar. He may be X, his identity may be or may not be known. May not be known. Then, Benami transaction is also defined. A transaction or an arrangement where a property is transferred to or is held by a person and consideration for such a property has been provided or paid by another person. That is a Benami transaction. Now, recently, our Supreme Court, in the case reported in 2022, 141 Taxman, page 389, has held that the Amended Act 2016 is prospective in nature and no criminal action will lie under the old Act. But as per the Rajagopal Reddy judgment, the Benami Prohibition Act is prohibited in nature and it has no retrospective. So far as the applicability of the Act retrospective, section 4.1 and 4.2 has to be considered. Pending suit, if any suit is filed prior to the commencement of the Act, pending suit, if any defense is taken prior to the amendment of the Act, those suits and defense are permissible. The board means Central Board of Direct Taxes under this new Act. Now, let us see some of the important judgments to know about the applicability of the Benami Transaction Act. In 1974, 1 SEC page 3, Jaya Dayal Border versus B.B. Hasra, the Supreme Court has framed certain guidelines to know whether the transaction is a Benami transaction. Number one, the sources from which the purchase money came. Who has paid the purchase money? That has to be considered. Then the nature and possession of the property after purchase. After the Benami transaction, if the property in the name of Benamidar is enjoyed by the real owner, that has to be considered. Then motive, if any, for giving Benami color. What is the motive? What is the relationship between the real owner and the Benamidar? Why it was purchased in the name of the Benamidar? Why the Benami color has been given? These things have to be considered. Then the position of the parties and their relationship between themselves, and the custody of the title deeds after sale, and the conduct of the parties concerned in dealing with the property after the sale. So these are all certain 6 guidelines framed by the Honorable Supreme Court in 1974 on SEC page 3 to find out whether the transaction is a Benami transaction or not. In 2001, AR 2001, Allahabad, page 366, the presumption in India, so far as the property purchased by a Hindu husband in the name of his wife, is a Benami. But such presumption is rebuttable. Then, if any property is purchased Benami, and if it violates any provision of any law or defeats the rights of the innocent transferee for value from the Benamidar without notice, the object of the Benami transaction is to defraud the creditors of the real owner, and if it is against public policy, the same has not been given effect. This is 2004, 8 SEC, page 355. In Tamil Nadu, a famous cine actress, Sri Vidya, he has purchased a bungalow from and out of her hard-earned money in the name of her husband, George. Later dispute arose. Sri Vidya was sent out from the house, which was purchased by her in the name of her husband. Husband pleaded that after the advent of this act, Benami transaction is prohibited and he is the owner of the property. Sri Vidya cannot lay any claim for declaration of his title to the property. But the Honorable High Court, by taking into consideration of the guidelines framed by the Honorable Supreme Court, reported in 1974, 1 SEC, page 3, declared that Sri Vidya is the absolute owner of the property and ordered to recover possession from her husband. This is 2003, 1 CTC, page 705. In one case, that is Muttaya versus Rajam, reported in 2023, 4 CTC, page 720. The dispute is in one of the partner purchased property in the name of another partner in his individual name. And it was argued that the Benami Transaction Act will apply and it is not the property of the partnership firm. The partner in whose name the property was purchased in his individual name, he is the owner of the property. Repelling such a contention, the Honorable High Court of Madras has held, by virtue of Section 88 of the transaction, that was not repealed under the new Act. Section 81, 82, 90 was repealed, not Section 88. Section 88 of Trust Act deals with advantage gained by fiduciary. So the partner is a trustee for another partner. One partner is in fiduciary relationship with another partner. So if any property is gained by advantage gained by the beneficiary, fiduciary relationship, then what is the legal effect? That is dealt with under Section 88 of the Trust Act, where a trustee, executor, partner, agent, director of a company, legal advisor, or other person bound in a fiduciary character to protect the interest of another person. Advocate, we used to get money from the court which are payable to our client. We can't say that we are the owner of the money. We are having the money on behalf of our clients. We are in fiduciary relationship with our client. So we are bound to return the money received by us from the court which are payable to the client. By availing himself of his character, gains for himself any pecuniary advantage, or where any person so bound enters into any dealings under the circumstances in which his own interest are may be adverse to those of such other person, and thereby gains for himself a pecuniary advantage, he must hold for the benefit of such other person the advantage so gained. So the advantage so gained by the person in fiduciary relationship is bound to protect the property and bound to hand over the same to the person on whose behalf he is holding the property. In this case, it has been held that the property purchased in the name of another partner in his individual capacity was thrown into the hodgepodge of the partnership firm, and it has been treated as a property of the partnership firm, and the purchase money was paid from and out of the partnership firm. So it has been held that it is the property of the partnership firm. The Benami Transaction Act has already exempted this kind of transaction even under the new Act 2016. Then the Division Bench of High Court had an occasion to consider the property purchased by the husband in favor of his wife. The husband contended that he has not purchased the property for the benefit of his wife. He has purchased the property in the name of his wife because purchasing property in the name of his wife is a luck to him, because the property will give enormous wealth and he will gain more whenever the property is purchased in the name of his wife. That is, in luck he has purchased. In Latin, it is known as felcia. So only he has purchased the property in luck in favor of his wife. Wife take a stand. No, that property was purchased by her from and out of the funds provided by her father. By taking such a plea, he lost his case, because that plea is contrary to the presumption available under the old Act 1988. It is for the husband to prove that the property was not purchased. The property was purchased not for the benefit of his wife. But when the property was purchased in trust or in luck in the name of his wife, not for her welfare, then he is the real owner of the property, and declaration can be very well be granted in favor of the husband. Then the Division Bench of High Court had an occasion to deal with the power of attorney sale by a company. Then it has been held, in the absence of transfer of title, the concept of Benami transaction cannot be inferred. This is reported in 2023, 6 ETC, page 113, division page. Division. So, now just to give the outline and skeleton of this act, both 1988 and 2016 act, I would like to say property can be purchased in the name of another by providing his own fund. Then it is termed as a Benami transaction. When there is no dispute, there is no problem. When it is brought to the knowledge of the initiating officer, namely the Assistant Commissioner or Deputy Commissioner of Income Tax Act, as the case may be. Once show cause notice is issued under Section 24(1), the Benamidar has no right to execute sale deed in favor of any third party. Such transfer is prohibited. And under the new act, the Benamidar has no authority to retransfer the property purchased in his name to the real owner. To the real owner. So, because of this amended Act 2016, the government, the central government, is able to confiscate properties worth about several crores of rupees. Because after the demonetization, the bigwig politician or person having ill-gotten money used to deposit their money, ill-gotten money, in the name of some companies. Those company was running in loss for the past several years. One fine morning, the company able to show that these are all the huge profit earned by us. Then the income tax authority put a question, what is the source of income? They are unable to give answer. They are unable to give answer. So the entire properties of the persons, those who are all not able to furnish information that these are all the source of income to purchase the property, entire property was confiscated by the central government. Central government. So this 2016 Benami Transaction Amendment Act is one of the finest legislation. Finest legislation, and it has to be cherished. So there is no bar so far as the Karta of the Hindu joint family to purchase property in the name of member of the joint family or co-partner, and by the spouse in the name of another spouse or in the name of their children, or by brother or sister in the name of another brother or another sister, provided that must be some document to show that they must be declared, they must be shown as joint owners. Only these exceptions are carved out. Other, in respect of others, the law strictly says it is a Benami transaction that is prohibited under the law. Both the real owner or beneficial owner or the Benamidar have no authority either to file a suit or to retain the property or to sell the property, appropriate the sale proceeds, and retain the same with them. Retain the same with them. And now the court is designated in the care of Sessions Judge to Session Judge, and the tribunal has also been constituted, and as against the tribunal judgment, appeal will lie before the High Court, but such appeal can only be entertained only on pure substantial question of law, as in the case of Section 100 of CPC. 100 of CPC. So the offense under Section 3, 53 and 54 of the 2016 Act is not cognizable. No plea bargaining is permissible. So in the next session, I will give my lecture from section 1 to till end and explain the intricacies of the new Act 2016.
Yeah.
This
There's one question. It says if it's reverse scenario, like purchase the property by husband and his wife's name, then sir, what will be this transaction treated as?
Pardon? Yes, I will. With reverse, like purchase the property by husband and his wife's name, then. Same. If wife purchased the property, that was not contemplated under the earlier Act 1988. Perhaps the legislatures were under the impression husband alone can purchase the property in the name of a wife, and not by the wife in the name of her husband. But under this new Act, wife can purchase property in the name of husband. Husband can purchase the property in the name of wife. There is no need that the purchase is for their welfare. What is required? The purchase money must be from the known source of income. Yes, if the another question, if the property is held as Benami property, then the property covered under the sale deed, that is a Benami property, will be confiscated by the central government. Then it will become the property of the central government.
That is the only question I've seen on the YouTube also. Yeah, one question has come. This is if a person purchases a property in the name of his son-in-law as a dowry, please take a claim on the property as a real loan later on.
No. That is prohibited under the new Act.
Yeah. This is.
Any other questions? Let them put it in chat box.
No. So,
if joint owners property documents, there must be some documents. Brother and sisters both purchased some properties in their name. Once the document is shown, then there is no legal bar to any one of the son or brother or sister to purchase the property in the name of another sister or brother. But in each and every case, the 2016 Act emphasized the purchase money must be from the known source of income. It should not be from any ill-gotten source.
These are the only questions. Thank you, Shankar. And thank you, Lakshmi, for sharing the knowledge. Thank you, everyone. Stay safe, stay blessed. Namaskar.